Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests. I'm Fernanda.
And I'm Marta.
And today we have with us the winners of the 4IP Council Research Award 2023.
The winner of the first position is Dheemanth Vangimalla. Hello, Dheemanth.
Hello, thank you for having me here today.
On the second position, we have Aline Arenque and Amanda Costa. Hello, Aline and Amanda.
Hello, hi, I'm Aline. It's a pleasure to be here today.
Hi, Marta. I'm Amanda. Thank you so much for inviting us here today.
And on the third position, we have Ángela Martínez. Hello, Ángela.
Hello, everybody here. Thanks for having me today. Pleased to be here.
Well, thank you. Thank all of you for joining us today. And we cannot wait, Fernanda and I, to hear about your research and a little bit about yourselves as well. So let's get started.
So, Dheemanth, could you provide a brief summary of what your article is about?
Sure. So my paper discusses the plausibility requirement in patent validity. And for those who are unfamiliar with the term, plausibility essentially refers to an evidential requirement. So it's all about evidence in a patent and how much evidence, if at all, a patentee has to include to support the technical effect that they say their invention has. So in the paper, I talk about the origins of the plausibility requirement, as it's a relatively new concept in patent law. I discuss how it started at the European Patent Office in its attempt to tackle speculative patenting. And I then go on to discuss how it was adopted by the EPC member states. And I focus on the UK. I then go on to talk about some divergence that has emerged between the English courts and the EPO. And I don't think I'm saying anything particularly controversial by saying that there is divergence. And then I go on to discuss whether or not that's actually justified.
You mentioned in your paper that the term plausibility and the evidential requirement that it represents has its critics. Why has the mere existence of plausibility been criticized?
Well, it's been criticized in a number of ways. Firstly, it's not an explicit statutory requirement, as in you won't find the words plausibility or credibility or any other manifestation of the term in any patent statute. It's been described as a court-invented concept, so there is a legitimacy question attached to it. And indeed, there are practitioners and academics who remember a time where there was nothing like a plausibility requirement in patent law. The second reason it's controversial is, as I've already mentioned, plausibility was adopted to tackle speculative patenting, so the so-called armchair inventor. You can picture a person sitting in an armchair, eating a bowl of popcorn and thinking about all these various chemical formulae, and then submitting a patent application based on those formulae without actually having done any experiments or having any intention to commercialize those chemicals. So you have a group of people who think that that's really shouldn't be what patent law or the patent system encourages, and they're in support of a plausibility requirement. But then you have another group of people who say, well, hang on, that armchair inventor has come up with something that is novel, that is non-obvious, and satisfies all the other requirements for patentability. And eventually that chemical is going to enter the public domain after the patent expires. So they are contributing to innovation. So what's the issue? Why shouldn't they have a patent? And they're against a plausibility requirement. And that's where the debate gets really heated. And then another reason why it's controversial is the way that the courts have gone on to apply the evidential standard. And that's really what my paper talks about. So I won't say anything more. People can go and read the paper.
Yeah, I want to remind all our listeners that they can find the papers on our website under research. And now we are going to move on to Aline and Amanda. And I would like to know a little bit more as well about your paper. So if you could give us, please, a brief summary, that would be great.
Yes, sure. So our paper is about the video games evolving industry and IP negative space, as the title mentioned. So we select video game industry because it's a thriving sector. Since pandemic, the numbers have exploded, and we wonder ourselves how this success can be related to the complex exploitation and enforcement of IP rights. So in our paper, we have selected three market practices that are piracy, modifications or mods, and game cloning. These three different market practices, they do not, of course, cover the entire video game industry, but they are examples of how complex can be to enforce IP rights in the video game sector.
I'm very curious about this expression that it's in the title, the negative space. So, could you provide a bit more detail of what do you mean by IP negative space?
Yeah, I think Amanda is the best one to answer this.
Thank you, Aline. Yes, this was what I was most interested about in this paper. And actually, negative space is when you don't enforce your IP rights. So even though you have a right to have a copyright over a music, a song, a book, a video game, for example, so you can exclude everyone else from enjoying this intellectual creation of yours. However, even though you have this right, you can do it, you don't. You don't because you have other incentives as an industry. For example, if people hear this music, if people read this book, you can get more copies sold, you can be more famous. So it's better for your business if you don't enforce your IP rights. And you got to a point where we ask, do we have this in the video game industry? Do we have a negative space? And the answer is quite interesting, but I'm not going to spoiler anything right now.
I love the mystery. And so now it's Ángela, it's your turn. Could you provide a brief summary of your article?
So, in my article, I present the conceptual foundations for an artificial intelligence powered model for quantifying similarity among plant variety denominations. So, I think that a contextual background is needed here for those who do not know about plant variety rights. So, let me start first introducing the main character in this story. So, the plant variety denomination, what is this? So, this is the generic designation that you give to a specific plant variety so that it can be easily identified in the marketplace and distinguished from others. Now, the plant variety denomination is also a requirement to get intellectual property protection for your plant variety. It is the applicant that has to propose a denomination, and then it is the competent plant variety office that needs to examine it in accordance with the applicable rules. Now, one of these rules is that the denomination cannot conflict with an earlier registered denomination. So it cannot be identical or highly similar to an earlier denomination. And for this, we need or it's really needed like an algorithm that is capable of exploring or scanning through a large database and retrieving all the similarity rankings with these earlier denominations. So here is where an AI model comes, and denominations are analyzed a bit like trademarks. So you analyze them from the visual, the phonetic, and the conceptual perspective. And therefore, the AI model must cover these three separate modules to get to the result on whether there is a likelihood of confusion between the two confronted denominations. And then, of course, it is very important when you conceive an AI model to think of the audience targeted, because I conceive the model as a bicephalous creature. So you have, on the one hand, one head, which is the back office used by the examiners, and then you have the front office interface used by the applicants, by the external users. And in fact, of course, everything converges in the same data sets, but then the way you present the model to the different type of audience is different. And I provide all the details in my paper, which I invite you now to read.
So, Ángela, which type of audience did your article target? That is, who would you say could benefit most from reading the article and implementing the AI building blocks you describe?
So, well, first of all, I wrote the article with a general audience in mind, meaning that the way I write can be easily understood by both lawyers and data scientists. Then the most interesting type of audience certainly includes plant variety offices and plant variety experts. But then, given the cross fertilization between the fields of plant variety examination and trademark examination, these building blocks of my proposed model can also be useful for trademark offices and for trademark specialists.
Um, Thank you so much, Angela. Now we are going to go back to Dheemanth, and I would like to ask you about the motivation behind your paper. I'm going to say the name of the paper so that everyone knows is Plausibility and the Flotilla. Have the English courts drifted from the commodore's approach to the evidential requirement for patent validity? And if so, is this divergence justified? Whoa, that's a long name. I hope I said that right, Dheemanth. And yeah, I would like to know what motivated you to write it.
Well, yes, no, I completely appreciate that the title to my paper is a bit of a mouthful. Um, well, I had to write something for my master's degree, didn't I? And that's kind of how the paper came about. But on a more serious note, I hadn't done any IP law before starting my master's at UCL, so University College London. So I'd met with one of the senior lecturers over there, Dr. Matt Fisher. I did this before my program started, and he took the time to sit down with me and discuss potential topics based on subject matter that I was interested in. So pharmaceuticals and the pharmaceutical industry, and so on. And he kind of directed me towards down the plausibility path and the debate surrounding the topic, and that's where the paper started from. After my master's, I started working, and I'm still am working as a research assistant at the UCL Institute of Brand and Innovation Law. So that's the IP Institute at UCL. And one of my bosses informed me about the competition, and that's how I went about submitting my paper to 4IP. I'm sure my co-winners will share this sentiment. And I do have to say this, we all stand on the shoulders of other people, and I'm really no exception to that rule. So I'd really like to mention a few people without whom I wouldn't have a paper and I wouldn't have had the opportunity to submit something to this wonderful competition. Well, firstly, my wife, Jess Simpson, who's put up with me for several years now. My master's supervisor as well, Joshua Bradley, who is brilliant, and I can't overstate how invaluable it is to have the kind of patient supervision that he provided. Sir Robin Jacob, the director of UCL IBL, and Dr. Lynn Chave, and the rest of the wonderful and brilliant team at UCL IBL, all of whom were very supportive and encouraged me to actually submit something to 4IP. Being someone who was relatively new to IP and new to legal research, it's quite a daunting thing submitting a paper to an international competition. And if I can say just one thing for any listener who is in the same position that I was in, so someone who's new to IP, new to legal research, if you're thinking about something to write, you really need to start with the subject matter. You need to find something that you're actually interested in, because, I mean, let's face it, law can be a bit boring. And if you pick something that purely because it's just topical and you find it boring, it's going to make things much harder when it comes time to writing, because writing is difficult. And it becomes so much easier if it's a topic that you're actually interested in. And if you're doing a dissertation now for your undergraduate or for a postgraduate program, It doesn't take much work to convert that into something that you can submit for this 4IP competition. So please do, if you're thinking about it, just submit something.
Yes, please do. We have already opened the competition for 2024, so we are already accepting papers for this year's competition. So we will make sure we add the link on this podcast so that people can easily find it. Thank you so much, Dheemanth, for your message. I think it was spot on. So thanks a lot.
So I would like to ask the same question for Aline and Amanda. What motivated you to write the article? IP negative spaces in today's evolving video game industry.
Amanda and I, we met at our master program at Nova School of Law in Lisbon. And we are passionate about research. We are part of Nova IPSI Knowledge Center, which stands for Intellectual Property and Sustainable Innovation. And we really wanted to put our research skills to proof because we were discussing on our knowledge center about video games because this is what I am researching for my master thesis, but from a different perspective. And what Amanda was researching at that time was about negative spaces. And here I completely agree with Dheemanth when he says that we need to find a topic that we are passionate about because this makes the research much funnier and interesting. And as I mentioned, Amanda and I were researching about different things, but we thought it could have a match between these two topics, and this is where the article came from. We want to acknowledge Nova IPSI researchers as well to help us in this discussion. They were very a part of this article as well, and also to thank Professor Julia Piora for her feedback. Professor Julia Piora is the coordinator of this knowledge center.
Actually, we are familiar with Professor Julia Priora because we have interviewed her in this very podcast. So whoever wants to also listen to that episode is welcome to find it on our website. Thank you so much, Aline.
No problem. Thank you.
Amazing. I really like the fact that you highlighted that she's a good partner in the research. I've done research together with people as well, and it's really nice when it's a match.
Yes, this is the second paper that we write together, so it's been awesome.
And now, Ángela, so same question for you. What motivated you to write the article, The Building Blocks of an Artificial Intelligent Model for Quantifying Similarity Among Plant Variety Denominations?
So my motivation was threefold. So for everybody to understand, you can visualize it like a triangle with three sides. So one of the sides, the first and most important one, is my curiosity and my intrinsic motivation for researching and writing. And in particular, I have a personal interest in this subject matter. So the point of interface between two fascinating domains. So you have, on the one hand, computer science, and on the other hand, plant variety denominations. So this was the perfect combination to me. And the second side of the triangle, of course, I did this in an academic context. So in the context of the of a university diploma on artificial intelligence and IP with the Center for International IP Studies of the University of Strasbourg. So I, of course, need to take advantage of this opportunity to thank Professor Jean-Marc Deltorne for all the knowledge that he transferred onto us. And lastly, so the third side of the triangle is the practical use of the work, because I like following pragmatic approaches in my research. I like writing empirical articles that contain elements that can be applied in practice. So that would be it, the motivation.
So thank you everyone for your answers. It's really interesting to know your perspective. And going back to Dheemanth with this next question that I really like is, what is one thing that you want the audience to know about your paper?
Well, About my research, well, I have to say, don't expect to find a magic bullet answer in my paper. I'm great at asking questions. I'm just not great at having answers for them. And that really comes out in my paper. So in my paper, I've explored the EPO, so the European Patents Office's approach to plausibility over the years. I do the same with the English courts. And then I go on to talk about how they've diverged. I then discuss what evidential standard for plausibility probably strikes the right balance, taking into account the various interests at play. And then I go and ask a bunch of questions to which I don't have an answer. So please do read my paper. And if you do have any answers to the questions that I ask at the end, please get in touch.
I really love that. Yeah, and I think the best research is basically the one that is, happy to bring up a lot of questions, and maybe, of course, some of them won't be answered. So, yeah, thank you so much, Dheemanth. So, I would like now Aline and Amanda to answer the same question. So, if there was one thing that you would like your audience to know about your paper, what would it be?
Well, if it's only one thing, is that what we demonstrate in our paper is that the complex enforcement of video games. So we don't have video games are a complex subject matter. So you have a lot of things that you can protect with copyright law, for example, and this is well established in the doctrine. But what we are talking here is not about that subject matter. We are talking about the enforcement and how complex this enforcement is. So if you are interested in learning how to enforce your IP rights on a game, you should really read our paper.
Thank you so much, Amanda. I really like your answer. And now the same question goes to Ángela. If you could tell one thing about your paper for your audience, what would it be?
It would be that, in this paper, I outline the general lines of the model, but then if this model were to be applied in practice, then the nitty-gritty and the details, they need to be defined depending, again, on the audience, on the office that wants to apply it, and so on. So it needs to be adapted. Then I also wish to add that the field of plant variety denominations is an excellent field of research because you can explore untrodden paths. And I also wish to mention that there is an extended version to this paper. So if you want to have access to the premium version, don't hesitate to get in touch, and hopefully it will see the light soon as well, the extended version.
Thank you so much, everyone, for spending this time with us. It was such a pleasure to get to know you and also get to learn about your papers. And they were all such interesting topics, right, Fernanda?
Yes, absolutely. I would like to thank everyone as well and tell our audience to go to our website, read their papers because it's really interesting and they deserve it to win the competition.
Thank you. Bye-bye.
Thank you. Bye.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.